All right, let's get started because we've got a fair bit to get through today. Want to firstly thank everyone for joining us for our inaugural Spotlight on Financial Services series, where industry experts are discussing the latest issues facing the sector. My name is Eden Winokur. I'm a partner and head of cyber at Hall & Wilcox. Today, I'm delighted to be joined by James Morvell, who's a partner at Hall & Wilcox too, as well as Teresa Lewin, the Financial Institutions Practice Leader at Gallagher. Next thing I want to do is just give an acknowledgement of country. I'd like to acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the land I am presenting from today. I recognise their continuing connection to land, waters and culture, and I pay my respects to their elders past, present and emerging, and to all First Nations people joining us. Next is just a quick housekeeping message. If at any stage you have questions you'd like to ask, please put them in the Q&A box at the bottom of the screen. We'll be addressing questions at the end of the webinar. And if we don't get to yours, feel free to contact us afterwards. If you have a comment, you can pop it in the chat box. Please note it's not anonymous. Also, please note that today's session is being recorded and everyone will be sent a copy of the recording. So getting those issues out of the way, we're talking here about cyber. And cyber is an incredibly important issue for the financial services sector. And it would be remiss of me not to just mention up front that cyber received more attention in yesterday's budget than really in any budget that we've seen in Australia before. Just a few things I wanted to note. The federal government has put aside tens of millions of dollars for the Office of the Australian Information Commissioner, or the OAIC. That's to cover the costs of regulatory action, enhance its data and analytics capability, and to support the setup of a standalone privacy commissioner. So we're going to expect to see more enforcement action at the very least from the OAIC. Tens of millions of dollars has been put aside for small businesses when it comes to cyber resilience. I'm sure that will be welcomed by those businesses and the community in general. And in addition, there's been money set aside to set up a national cyber leader at a federal government level. So a lot happening in this space. And I'm sure those who have tuned in will no doubt be very interested in cyber and its impact on the businesses that you work in. In terms of this presentation, both myself and James will be asking questions. So without further ado, I'm going to hand it over to James to get things started.
Thanks, Eden. Good morning, everyone. I'm in my role as a corporate partner. I'm regularly talking to clients about the risks they face, and in years gone by, that hasn't tended to really touch on technology-related issues, or certainly anything to do with cyber, but is increasingly becoming a topic that we discuss regularly, and I defer to you and others, and Teresa in particular. In your role, I expect that you're regularly discussing cyber with your clients, in particular with directors and management teams. But more specifically, what are they saying to you at the moment around the current cyber landscape, their specific concerns, and what they're doing to keep up with the evolving regulatory regime?
Thanks, James. And you're right. Rarely do we have a conversation with the client where cyber doesn't come up. Our clients, including their boards and their exec leadership team, as you'd expect, are seeing management of the cybersecurity of the organisations as a priority. But they are really concerned about their responsibilities. The organisations are concerned about the potential of a breach and what impact that's going to have on their business and their reputation. And that could happen no matter how much they invest in cybersecurity, how much they educate their employees and enhance their cyber readiness. Directors in particular are particularly concerned about their responsibilities, and are they doing enough to satisfy the stakeholders, such as employees, customers and their shareholders, and also the regulators if there were to be a breach. We know that in 2022, the AICD in partnership with the Cybersecurity Cooperative Research Centre, developed the Cybersecurity Governance Principles. And this was to help the directors with the oversight and management of cybersecurity risk, which was really useful. And James, I understand that that you also provide advice to organisations on their compliance with their general obligations. So it's great that that's there. But there is a concern, though, that there's too much regulatory complexity. There's compliance with the Corporations Act, SOCI, Privacy Act, CPS 234, just to name a few. And then they've all got different data retention requirements. So staying on top of it is really a challenge for the directors. We understand that one of the proposals in the recent 2023-30 Australian cybersecurity strategy is to consider one cybersecurity act. And, that would be really welcomed by our directors. Although I'm not really sure how it would work to try and put all those regulations into one act or most of them in there. But another proposal in that ACS strategy is to potentially introduce new requirements for directors. And we're not sure that this is really necessary given all the legislation that's currently in place. Introducing further guidelines and requirements could bring around changes that really aren't ideal. And the board and the exec that we're speaking to, want to focus on proactive cyber resilience of an organisation rather than pure cyber compliance. And we don't want an environment where the level of compliance significantly dampens or restricts innovation or new technology and services or new ways of operating. And that's the concern that, we're hearing. Organisations are also grappling with the impact of sanctions on the payment of ransoms and even just the legality of paying those ransoms. We hear different opinions all the time. And finally, the other challenge that our clients are mentioning is confusion around who to advise and when in the event of a breach. And, this includes the ASX in order to comply with the continuous disclosure obligations. One of the Medibank actions alleges breaches of this act. So it is really challenging. And we know that there's a number of reviews that are currently being undertaken at the moment into the cyber framework in Australia. So hopefully some of these challenges will be addressed in the near future and provide some certainty to our clients. Thanks, James.
No, thank you. You've touched on some interesting areas there that I practice in around sort of the more general obligations for directors. And even we discuss these regularly, sort of where there's that crossover between your speciality around cyber and mine around sort of governance in the context, in particular, of financial services businesses.
Mm. That's exactly right, and I think Teresa makes a number of really great points, and that's really probably a good stock take of where things are at in corporate Australia when it comes to cyber and the issues that Teresa, your clients are considering and dealing with. It is a bit of a minefield. So that's part of what I do is try to provide that advice to directors if they have an incident, get in and sort of explain that regulatory landscape. But it is a challenge because there are often competing timeframes to notify. Different regulators need to know certain things. Notifying one regulator might trigger an obligation to tell another, and so to keep up with it can be challenging. It's an incredibly dynamic area. And one that you really do need to be reading up on all the time to stay on top of. So I think that's a really good temperature check on where things are up to. James, I wanted to ask a question to you. Corporate and commercial partner, and in that role, amongst other things, you advise companies and directors on compliance with their general obligations and duties. And Teresa touched on that. When we look at the context of cyber, and we think about financial services companies and the work that you do, we've seen the ASIC and RI advice decision from 2022. We're not going to get into too much detail about that decision, but that was the first cyber-related case that was brought against a financial services company. Dare I say it won't be the last. And then in February 2023, we saw the federal court come down fairly hard on the directors of GetSwift for making misleading statements. In fact, the court issued penalties beyond what even ASIC was asking for in that case. And then on 27 February 2023, the Department of Home Affairs published the 2023-2030 cybersecurity discussion paper, which Teresa mentioned earlier. And in there was the question that Teresa sort of touched on about whether there should be specific rules for directors or specific laws relating to directors when it comes to cybersecurity risks. Now, having looked at a number of the responses to that paper, there seems to be sort of a general rejection of the idea of a cyber-specific duty. But we know that ASIC and other regulators are really focused in on this area. And the rejection of that specific duty is that the laws are already sufficient enough to deal with cyber risks. We just need to apply cyber to it the same way we apply all new emerging considerations. So in that context, what do you consider to be the key issues for directors in the financial services industry when it comes to cyber, and what do you think that there are? What are the things that companies can be doing about it now?
Yeah, it's an incredibly difficult landscape, and we all know, and everyone on this call will know that the financial services sector is quite possibly the most regulated in Australia among all industries or sectors. And really, in my sort of advice to boards, and when we're working through how to best manage these risks, you really start out the primary duties that directors are subject to. And so the duty to act with care and diligence really itself encompasses an obligation to manage the risk management framework of any business. In fact, the ASX Corporate Governance Council, which in my view has sets probably the benchmark for corporate governance standards in Australia, has specifically included in its latest edition the reference to cybersecurity when it's talking about the board's obligation to annually review and carefully scrutinise the risk management practices of the company. And that's at least annually, do that in a formal sense. To be quite honest, that should be really undertaken by the board progressively at every board meeting, getting updates on the status of the risk management platform of any organisation. But then when we think about financial services businesses, and probably most people involved in this discussion today will be part of or otherwise associated with an AFSL holder. And so by virtue of having an Australian financial services licence, there is then a further statutory obligation to act honestly, fairly and efficiently in managing that financial services business, because you are being entrusted with investor funds and then deploying those into different avenues or different ways, depending on the nature of your business. So that's where RI Advice really kicked in, looking at that organisation where there had been a series over a number of years of cyber incidents or deficiencies that were identified. It was found and it was admitted that there had been a failure to provide financial services in that way, in accordance with that duty. And I think what's important and what we learned from that situation is that wasn't an organisation that was blind to it and just ignored it. Where they were criticised by the court and ultimately faced penalties, where they didn't act promptly enough to address issues that had been identified. And I think what the court did in referring to it is they didn't necessarily join the dots to work out there was a systemic problem among their organisation and their authorised reps. And so what do we take from the situation? We take from it that there needs to be a regular sort of system of oversight and audit of cybersecurity measures, as there would be with other fundamental risks, such as financial risks in an organisation. But then when issues are identified, I think the court is now making it very clear to us, probably as well as through a lens of common sense, that you need to close those gaps quickly. The threat that exists is so prevalent that any gap that's left there can be exposed very quickly by a threat actor or an inadvertent failure to comply with policy by even employees to allow sort of exposure there. So I think RI Advice has taken it a little further. And then if I do just touch on then probably another area, which is then continuous disclosure. I think we'll come back to this a bit later when we're talking about class actions. But then we've got another regime that also exists around not just managing risk management, but what do you have to tell the market or tell people? So maybe we'll explore that in a little bit more detail further on, but that's sort of the matrix of issues that I think are most concerning for boards and management teams within financial services businesses at present. So that's probably where I'm seeing things, but I'm interested in an area that probably is not, I'm certainly not an expert in, but around privacy legislation, Eden, and privacy reform. I know that the Attorney General's Department released a report on the Privacy Act. We've been waiting for it for some time, knowing that this fairly significant and complex area of legislation was being reviewed. And there are, I think, well over 100 proposed amendments that come out of that report. That's going to take some time, I gather, for that complex legislation to be drafted and to pass through Parliament. But in your view, and you practice this every day, what should financial services business be doing right now in anticipation of that legislation and preparing for what's to come?
Yeah, I'm going to jump into that because this is a key topic that I've been speaking with clients about regularly. It feels like every day I'm on the phone with a new client talking about this and what they can do. Just wanted to make one brief comment, James, about some of your comments, because there's something that you said that really jumped out to me as an important takeaway from the RI advice case, and one that many people know, but there's no harm in sort of drilling in the message, and that's about making sure that when companies look at cyber, it's not just box ticking. It's not just have we identified gaps. It's about taking action and taking it expeditiously or being responsive to identified issues. To me, that was one of the key takeaways. The court expected organizations to not just identify issues, but to move quickly in responding to them. And really, it's an ongoing issue. It's sort of, I was saying to a client yesterday, this isn't let's get everything best in class and then put our feet up and hit the brakes or relax. It's going to require ongoing, forever attention. This is just part of the risks that come with the benefits that we have from the great uses that we get from technology in assisting us run our businesses. So I just wanted to mention that. I think just making sure that companies appreciate that it's important that we do all the right things, but then we need to stay on top of it and we need to move quickly to plug gaps. Now coming back to the question, which is about really the Privacy Act and what companies in the financial services sector can be doing. You're quite right that it's going to take some time for the proposals to be worked into a bill, and also right that the report from the Attorney General had well more than 100 proposed reforms. It was 116 was the exact number, and it has been years in the making. Consultation was open until the 31st of March. So that's now closed, and there were a significant number of submissions from stakeholders who wanted to have their opinions noted, and for the government to consider those submissions in formulating whatever bill is put forward. What I would say at the outset is that I think there's a community expectation that the government moves on reforming our privacy laws. I think our cybersecurity minister and Attorney General have said that our laws are sort of maybe not fit for purpose anymore, or they're a bit dated, and just with some of the major breaches we've seen all over the headlines of our nightly news in the past 6 months, or a bit longer than that now, 6 to 8 months. I do expect that the government will move promptly on putting together a bill. With that said, it is going to be complex, and there are a lot of aspects to this, and so it's not something I'm expecting to see in the next week or two, but I would be quite surprised if we didn't have a bill and potentially a complete reform of our laws by the end of 2023 or at some time in 2024. If we were still talking about this in 2025, I'd be surprised, is the message I'm really getting at. And it's also important to note that our privacy laws have already changed. So in December 13th of 2022, a privacy reform did come into force, which rapidly or drastically increased the maximum penalties that can be sought to be imposed by the Privacy Commissioner for serious and or repeated breaches of the Act. So before 13 December, maximum penalty, 2.2 Australian million dollars. For some businesses, that sort of cost of business, and the OAIC has been quite judicious in the way that they have enforced the privacy laws, but now the maximum penalty is up to $50 million. So far more significant, and there's additional ways that the OAIC can penalise, but I just want to the headline number is 50 million. There's also a percentage of revenue as a potential option, but suffice it to say 50 million is sort of the headline number that business should be aware of. Now coming back to sort of the specific question, what can businesses be doing? Well, our laws are going to become very similar to what we see in Europe with GDPR, considered sort of the world's leading privacy regime. I went to a talk that the Privacy Commissioner gave last week where that was the words she used. We want to have a sort of GDPR style privacy law. So we should expect that to come. That's clearly what the reforms seek to do. But we're not there yet. We don't know exactly what laws are going to be changed. And so the idea that businesses spend a lot of time and money, meeting all these potential reforms. If you can do it, great. But in practice, my experience is that, we don't want to sort of shadow box too much. But with that said, there are a number of key things that can be done right now to reduce your overall risk and also make sure that businesses in the financial services sector are ready once those privacy reforms come into force. And the two key things I would encourage businesses to look at right now, the first is data collection and retention. That is the hottest topic in privacy right now for businesses across Australia, including in this sector. Obviously, with some of these major breaches, it became a hot topic. Why are they collecting so much data? Do they need to hold it? They don't need that. They've confirmed my identity, or I've finished paying off my loan 10 years ago. Why do they hold that data? That's looking at it sort of from a retail or telco perspective. I encourage businesses in this sector to look at their customers the exact same way, and even their employees. If an employee finished up 6, 7 years ago, 8 years ago, do you need to continue holding that information? There are some complexities around minimum retention periods, of course, and we're working with a lot of clients to, create retention policies that outline the retention periods and also understand, what information is collected and that's actually needed to run your business. So key thing for businesses right now is to stop and do a stock take. Do a data mapping process. Do you know what data you hold? And if you don't, start preparing it. Start speaking to experts and figuring out, how do we understand what data we currently hold? That's step one. Step two is to say, all right, well, when we no longer need data for the reason it was collected, and in particular personal information about customers, and in the financial services sector, you can think of plenty of scenarios where businesses will be collecting really important and sensitive financial information about customers. It's really important that businesses start looking at deleting or de-identifying that data when it's no longer needed. So that's the key thing I'd be encouraging businesses to do. You already have a legal obligation to do it under the Australian privacy principles, specifically APP 11.2. But I think that there's a lot more work to be done in this space for all companies and particularly those who are collecting financial information. So that's probably the first thing I'd recommend, is think about your data practices. The second tip I'd give to businesses right now is really to look at supply chain or sort of the third parties who we contract with who might have access to our data. And that could be a cloud service provider. It could be really any sort of company which is able to get in and get your data flowing into their networks, or anyone who logs into your network to provide business services to you. Who has access to your data? And then another sort of thing to flag is file transfer platforms. So a lot of organizations, law firms, companies in the financial services sector will send out large file transfer requests, thinking that documents that are going to be sent across are going to be done so via secure platforms. In practice, in cyber, we have seen significant data breaches where these secure platforms have been hacked, and basically a large number of organizations have had data that they were sharing, which they understood to be secure, but they've had those documents exfiltrated and had criminals come and try to demand ransoms for payment to stop that data being published. That's happened to public sector companies, private companies, publicly listed companies, you name it, but really unfortunate situations when you have a large number of companies impacted by a single attack. So looking at your supply chain is really critical. What can you do about it? Well, I asked a question of the Privacy Commissioner last week at this talk that I attended about her opinion on this very issue, because it's something I see come up regularly. And her view was that, it is a challenging space. Going to one of the large cloud providers and asking them to change their terms of contract is probably going to be met with a swift no. But where you can, businesses in the financial services sector should really be thinking about this issue and should be thinking about what clauses can be put in contracts to ensure that data is being protected. If there is a data breach, making sure that the investigation can take place efficiently, and that if there needs to be notifications to the Privacy Commissioner, that it's done so in a way that is sort of governed by the contract. If possible, that is the tip of the Privacy Commissioner. That's best practice in her opinion. So just wanted to share that with those tuned in today. 2 things you can be doing right now: data mapping, data deletion, sort of data processes, that's 1. And 2, just think about who's got access to your data and how secure are they, and what happens if something goes on their end. What are you doing to protect yourselves right now against those risks? So I'm mindful I've just sort of talked a fair bit there, and that's just two things coming out of the Privacy Act that we said there was 116 proposed amendments. So a lot more to come on that topic. But I want to move the conversation onto a topic which is very important to me, and I'm sure Teresa as well, and that's actually sort of cyber insurance and just insurance in general. And we heard a bit from James earlier about processes and sort of the importance of having good systems and moving quickly that companies in the financial services sector should have in place. And really, when we think about sort of risk mitigation in general, I mean, that's exactly what insurance is. It's risk mitigation. So Teresa, I've got 2 questions for you. Well, there's 2 parts to this question. First is, what are the different types of insurance policies that financial services companies can obtain to mitigate their cyber risk? And what do these policies typically cover?
Sure. Thanks, Eden. So insurance, and particularly cyber insurance, is a really valuable tool, as you've mentioned, for companies to assist them in the event of a breach. And there are a number of insurance policies which might respond to a cyber incident, and I'll touch on a number of these just now. Starting with the obvious, which is the cyber liability insurance. And these policies respond from the moment you become aware of a breach, providing you with 24/7 access to an incident response manager who can project manage the breach for you, mobilize a team of experts, which you will need in the first phase of a breach. Some of these experts include things such as forensic IT teams to determine the cause and the extent of the breach, and importantly, to actually try and terminate the threat actor's access to your systems. Crisis and communication specialists, and having been involved with a number of these attacks in recent times, you realise just how important this is. You're in there at 9 a.m. and you've got customers ringing you and wanting to understand why you can't give them the information they need. And you've just got to make sure that you've got a script and you've got a story for all of your staff ready as to why that's the case. Often, journalists may know, they might be sitting on the dark web and know about a breach to your organisation just as soon as you know about it too. So again, you've got to have those responses ready for them. The legal services to determine your notification obligations to regulatory bodies and the affected parties, who you've got to notify and when you've got to notify. We've mentioned this earlier. And Eden, I know you've acted for hundreds of companies in responding to cyber attacks and breaches, and I'm sure that you do this in your sleep now. that the costs to notify individuals affected or reasonably believed to be affected by the security breach is also part of the services that are mobilised initially, as well as the credit and identity fraud monitoring to affected individuals. And finally, the specialist ransom negotiators. Based on my involvement in a number of ransomware attacks, these aren't typical negotiations, far from typical actually, and you really need an expert in this area when you're negotiating with the threat actors. Alternatively, you know, some people will actually agree with their insurers that they want to use their own vendors in the event of a cyber attack, and that's also fine. But what we would say is, you know, you want someone to project manage it. What we've seen, you know, in some of these attacks is best cases, you have someone who actually mobilizes all the resources and manages them on your behalf, and it's proved really valuable. Cyber also provides other first-party covers such as business interruption as a result of a cyber attack. And I know a lot of people will say that they've got business interruption under their property, under their ISR, or under their business pack, but that will generally exclude cyber attacks. So it's really important that you also have that cover under your cyber policy as well. And then the final first party cover is the costs to review the affected data for PII information. And this can be really significant. Some of the ones that we've worked on, you know, if you've got a lot of data that's actually been stolen or accessed, and you have to go through all of that data to try and work out what PII information has been affected or been seen, then that can take a lot of manpower. You can also use certain tools as well, but you know, eventually it does come back to manpower actually reviewing that information, and it's quite significant. And then from a third-party perspective, the covers under your cyber policy include, you know, your damages and expenses resulting from a claim out of a privacy wrongful act or a cyber breach, your fines and penalties, and also your regulatory investigations. So they're all really valuable protections in the event of a cyber breach. And from a cyber perspective, there was an article in the AFR last year, which I quote all the time, because the headline was cyber insurance's dirty little secret, it's useless. Which I just love, because we agree that managing the risk is obviously the primary focus. But I'm not too sure that anyone who's been involved in a breach would say that cyber insurance was useless. I think they'd say quite the opposite, that it was actually essential. and it was a really important component in helping them to actually, you know, finalise that incident. Other classes, which we would also suggest can cover cyber exposures, are professional indemnity, directors and officers liability, and crime. Most PI policies will cover a component of breach of privacy, third-party claims of breach of privacy and breach of confidentiality. Important to note, though, in PI policies, always resist cyber exclusions as much as you can. And if they do put them on there, please look at them closely to understand exactly what is being excluded under the policy. But, you know, resistance is obviously the preferred avenue. And also other insurance clauses in PI policies and other policies, just to make sure that you're not going to end up with other insurance clauses in all policies, sending you in a circular direction and not being really clear which policy should be responding in the first instance. Directors and officers, very important cover for cyber, provides cover for claims brought against directors and officers in their capacity as such. And it could also include cover for companies for securities claims. We've seen actions against both organisations and their directors for cyber claims, including one of the Medibank class actions, which I'm sure, James, you're going to be talking about shortly, you know, which alleges, amongst other things, you know, breaches of the continuous disclosure obligations. Crime policies, there's a component of cover under these policies, usually sublimited for social engineering type losses. So reviewing your insurances and understanding how each responds is really a critical part of managing your risk from a cyber perspective. Your cyber insurance contacts and your incident response manager, your legal advisors should all be included on your incident response plan. And one of the things that we're finding really useful is actually having our clients introduced and meeting their incident response managers prior to any event happening. It's much easier to know what the process is going to be and who you're going to be talking to prior to actually the incident occurring. But yeah, to the incident occurring. So
that was a sensational overview of how insurance can help mitigate cyber risk, including the different policies focusing in on cyber insurance, just a couple of sort of comments that couldn't agree more. I mean, we act as the lawyers who get called in to help respond to incidents. Those calls before an incident are so helpful to get to know the right people, understand the decision makers, know a bit about the organization, and they get to know us. So they know who they're going to be speaking to. They get to meet the team who will help with the response should anything go wrong. It's a really good thing to have. We do a lot of work updating incident response plans, and couldn't agree more about your comment around including the right numbers to call. It's really important that it forms part of the plan. When to contact the insurer, how quickly do you call the insurer? Do you need to call the insurer if someone's clicked on a phishing email? Just understanding that what triggers need to be built into that process is really important for businesses, so that you get it right. And these things should be talked about and thought about before an incident, not during for the first time. And then just last comment on your that AFR article that you mentioned. I think that I know the exact article you're talking about. I mean, having personally been involved in hundreds of cyber insurance matters and seeing how much money insurers pay out under these policies, I was sort of astounded to read that article. And it just seemed like that article maybe hadn't spoken to a number of people who are on the front line in this area to see. I've been involved in numerous matters where cyber insurance effectively saved the business from going under. So it was sort of a bit disheartening to see that particular article and at least not provide the alternative perspective, but that's for another day. Let's move on to class actions. We've been mentioning it a few times, and I'm really keen to hear what James has to say. James goes and sits inside board meetings when for public companies when cyber attacks happen, and the company needs to figure out, do we tell the stock market or not? And James provides advice to boards about that. And what we're seeing at the moment, James, as you know, a class actions being filed in courts for breaches of, really for following cyber attacks. And we've already seen 3 filed against Medibank. The third one came in late last week, and one's been filed against Optus. So I guess I've got a 2-part question for you, James, that I think the listeners will find particularly interesting. First is, what are some of the considerations about whether a cyber attack on a listed company requires disclosure? So when you're sitting inside that room with the board, what are the key considerations to determine whether, yes, let's notify, or no, we either don't need to or we're not ready yet? That's sort of part one. And then sort of the second part of it, how important is it for lawyers to be involved in that process?
Well, I mean, the second question, goes without saying, doesn't it? It's extremely important for the lawyers to be involved, Eden. Look, this is a difficult area. Class actions and alleged breaches of disclosure against companies and officers is incredibly difficult, particularly because class action litigants and regulators inevitably have the benefit of hindsight when looking at a potential claim or prosecution. As opposed to the directors and management teams who were involved at the time an incident is threatened, is suspected, is occurring, has been identified. And so under pressure, with all the right people in the room, they are trying to deal with the situation, to limit the loss, and at the same time think about what are their other obligations at law to disclose information, whether it be under sort of data protection, privacy regulation, or what I'm particularly focused on with boards is their continuous disclosure. So I won't go into the technicalities of the continuous disclosure test. There are sort of some interesting elements, but essentially we're talking about non-public, price-sensitive information. And so the general test is for disclosing entities, and they are those that are listed on a securities exchange such as the ASX, but also unlisted disclosing entities, of which many financial services businesses fit that requirement as well under the Corporations Act. So we've got 2 bodies of regulation. We've got the Corps Act dealing with continuous disclosure. We've also got listing rules of exchanges such as the ASX. And there are 2, what we're seeing now, particularly with some of the pleadings that have come through in the Medibank class action, or one of them, there are two set of issues that are being, I think, examined and prosecuted or claimed against. One is there's been a cyber incident. The company hasn't told the market and shareholders, etc., who have either bought in or continue to trade or what have you. And at some point later on, when they've found out, there's been a drop in the share price or a diminution in value, as they say, that's the loss we've incurred. As a class, we're going to claim against the company for failing to have disclosed earlier what you should have done. You should have known, you knew about it earlier, and you should have told us. The other interesting one with Medibank, and I think there are some parallels with what we discussed earlier today about RI advice, is where there's been a failure to implement the appropriate measures to mitigate cyber risk. So Medibank required to comply with CPS 234, among other things. So it is alleged failed to do so and knew through the period leading up to the cyber breach that it hadn't met the requirements. One was, for instance, around multi-factor authentication. That was one of the things that is alleged that Medibank had failed in maintaining in accordance with its legal requirements. So that's a disclosure point. You were required to do certain things. You weren't doing them. You should have told the market you weren't doing them. And then there's the incident itself. So it's a very complex area. What I would say, and while many of us were spending an exceptional amount of quality time with our families during various lockdowns over 2021, Federal Parliament was very busy looking at continuous disclosure reform. And one important reform that was made was to introduce a fault test when it comes to civil liability for continuous disclosure breaches. So now it is the case, enshrined in the Corporations Act, that the entity and the officers involved needed to know or be reckless or negligent with respect to whether information that was of that price-sensitive nature should have been told to the market. So again, if you pull out in your spare time, looking to sort of get some bit more rest and you want to read some heavy pleadings, if you look at Medibank, the word negligent is used over and over again because it is appealing to the fact that, yeah, we're recognising there is a fault test, but those involved with the Medibank scenario were negligent in not disclosing the information. So it's a complex area. What can you do? I think, and that's probably the what can you do to mitigate this? And what are we finding that the courts are saying? And Eden and I have had a direct experience with in dealing with ASIC in a confidential investigation into a client where there was a suggestion or at least a question about whether it had complied with its continuous disclosure obligations. What ASIC got comfort with in our case, and what we're finding courts saying, is that what they don't want to see the management teams and boards just not even having regard to continuous disclosure, or being flippant to the fact that it's not material, it's not going to affect our business, or we're keeping it confidential and therefore we think we can rely on an exception without really testing it, or regularly coming back to it. So what we were able to show ASIC, Eden and I, in our particular instance, was through a very detailed time frame and fact pattern, was that we were meeting with the board, not just every day, often multiple times during the day, and with the other consultants involved in dealing with this particular incident, not just looking at what information had been exfiltrated, how are we dealing with our insurer, have we had confirmation of coverage, were the negotiations going on with the threat acts, but also, well, what do we know now and how does that affect what we need to tell the market? Do we need to tell? We need to have draft announcements ready to go. We should have a draft trading halt request ready to go, because as soon as the board makes a determination that the point is now that we need to tell the market, the test is immediate. It's not, in a couple of days or when you get around to it, when the lawyers have, really, applied their finesse to the announcement, the test is immediate. So I think that's the issue, Eden. It is about assembling your advisors. It's about having the internal teams ready to know how to respond, have those draft announcements sitting there as of now. Yeah, we hope you never need them, but have them there ready to go. Have a draft trading halt request if you're listed. And at least then, if you're finding after the fact you're subject to a class action claim, or probably more commonly, you've got a regulator coming to ask some fairly difficult questions of you, you say, well, yeah, what happened, but this is the process we went through, and we honestly believed we were doing everything within our legal obligations.
It sounds like, I mean, that's exactly what I would be recommending to companies, and where we got a really good outcome for the client in that particular ASIC matter you refer to, and deployed some I think really smart strategies to save time and money for the client in what it took to provide the response that ASIC was seeking, just by taking a common sense approach, but one where I think the approach taken, we were able to satisfy ASIC that the company had acted appropriately, and sought your advice and followed the advice in making the decision it made.
That's right. But look, every fact pattern is different. Teresa, so it's just without noticing, but I'm sure that's one issue that you're probably identifying as well, that no organisation is the same as another. The risk element to each one is different, and so it takes somewhat of a bespoke analysis each time. And I would imagine, without being in the calls that you're privy to, but that you're having very unique conversations in every occasion.
Absolutely. Every client is different. Every client is, has got a different data that they're retaining. So every conversation we're having with clients and the insurers is very different depending on their specific requirements.
All right. Just coming, I think we're going to have some time for questions, but before doing that, I just wanted to sort of go with part of today. We wanted to talk about mitigation. And so I've just come up with a list of sort of 5 key things that I want companies in the financial services sector to think about when it comes to responding and preparing for a cyber attack. So we'll do that. We'll then have some time for questions. We've got Sam Tamponi, who's a senior associate at Hall & Wilcox and part of the cyber team. He's online to go through some questions. But before we jump into that, I just wanted to, as I said, list 5 key things for companies in your sector to be thinking about. The first is really to make sure that you've developed and considered and you're constantly updating your security systems and policies. So that's the starting point. Point 1, policies. So, something to think about, is your company ISO 27001 compliant? If the answer is no, have a discussion with the internal team about what is that? What do we need to do? What's the benefits? It's really important to be proactive in considering these issues. The government will talk about the Essential 8. That's a standard that the Australian Cybersecurity Centre has published about. Same question, are we compliant with the Essential 8? If no, why not? What do we need to do? They are the things that businesses should be talking about. Is the incident response plan up to date and tested? We talked about that before. How does the incident response plan work as part of the broader business continuity plan? That's a really important thing. Are these policies fit for purpose? Do we have a data retention plan? What data are we holding? I talked about that before. And do we have systems in place, whether electronic or otherwise, that can delete or de-identify data when it's no longer needed? So, companies hold a number of records for 7 years. There's other retention periods that apply to. What are the automated processes that actually make sure your business is complying? So, number 1 tip, think about your policies, make sure they're up to date, make sure they're tested. Number 2 is preparation and practice are key. So what do I mean by that? Well, when was the last time your organization actually brought in, say, lawyers or other professionals to run through a simulated tabletop cyber attack simulation? That's a really important thing. How many times has the business's leadership thought about how it would respond to an incident? Has that been practiced? Have you identified areas for improvement? Who was involved in that? To me, that's critical. You want to be thinking about the key issues that come up should a cyber attack happen. And like I said before, you don't want to be thinking about these things the first time during an incident if that can be avoided. The third tip is that speed is key. think rapid. Rapid is the best response is a rapid response. Speed is critical when it comes to cyber attacks. It might be because there's someone inside your network and they are spreading and moving laterally to other areas, so you want to cut that off. It's also really important to make sure, and that's really about containing the incident. And then the other part of speed being critical is you need to figure out what you're going to be able to tell stakeholders. And so verifying exactly what's happened in a cyber incident can take time. It can be complex. You know, we've seen some of the biggest breaches in Australian history play out in the media, and we've seen facts change quite dramatically over short periods of time. And without sort of, naming and shaming, one particular organization said no customer's data has been impacted. And then 10 days later, every customer's data has been impacted. We're talking millions of people. How do you go from point A to point B in 10 days? It's really important that we move quickly, but understand, people should understand that that these things do take time. And I guess, one of the key things that I recommend is bringing in the right people who can operate quickly, who have got the experience to deal with these types of issues. So responding to a cyber attack is like getting heart surgery. You don't go to a GP, you should go to a heart surgeon. Like, that's sort of the way that people should be thinking about responding to cyber. And when you get the right people in, speed will be prioritized. I think I sort of touched on this with my last response, but the fourth tip is that accuracy is key. So making sure that when you speak to a regulator, when you speak to stakeholders, when you speak to the public, when you speak to customers, you're giving them correct information. Don't say, 300,000 customers and then change it to 14 million. Don't say no one and then everyone. That accuracy is key. If you don't know the answer, it's okay to say we don't know yet. We're still investigating. I personally would think, my personal view is that to change messages so dramatically causes more harm than being able to say, look, we don't know yet. We're urgently throwing everything at this to try and get you the answers. We'll let you know as soon as we can. And unfortunately, I've seen a number of companies sort of make that mistake, including some of the more recent breaches. So I think the key is communications at being accurate is really important, and it should be a linear story. It should go in one direction. We shouldn't be changing course as best we can, because the investigations do take time, and it's one of the great tensions that I observe in practice when we're helping companies respond to a breach. And I think, Teresa, you mentioned it, we're getting phone calls are coming in, key stakeholders want to know information, and unfortunately the answers are not known yet. And so how do you manage that communication accurately and have to give tough answers to questions for key people? And the last point I wanted to make, the fifth tip, is to know who to call. So that sort of goes to that point about the call in the heart surgeon when you need a heart surgery, but go and get vendors who are pre-vetted, who have got the experience. If you've got insurance, go and speak to your insurer about who's on their panel. If you want your own, bring your own vendors. Have a chat with your broker, have a chat with your insurer about that. My experience is that if you've got the right people involved, people will sort of want you to use people you're comfortable with, as long as it's being done in a reasonable way. But you should be having these conversations pre-incident, and meet the team you're going to deal with. Exactly what we talked about before. That's best practice. And so they're the 5 tips that I wanted to leave during this session. I might now pause, and Sam, I can see some questions have come in. Do you want to jump on that? Yeah.
Can I add one more to that list? Just based on experience, is be mindful where you keep your cyber insurance policy, where you store it, and also your financials if they're not publicly available, because we've certainly seen cyber actions where the first things that the threat actors take is the cyber policy and the financials. And when you're negotiating and you say you can't afford something, they'll say, yes, well, you can, because we've got your cyber policy and we've got your financials. So just something to be mindful of.
Great point.
Thanks, Teresa. So there's a couple questions in the chat and we have a handful of minutes, so we'll try to get to them. First question was for you, Eden. It's in relation to the security of critical infrastructure legislation.
Yep.
And particularly, what should super fund, insurer and bank clients need to know about it?
Yeah, great question. Thanks for the person who wrote it. I think the starting point is, does SOCI, security critical infrastructure, does it apply? So, you know, whoever's asked that question, or if you're talking to your clients, those clients should seek advice on whether it applies. If it does, then there's a number of things that the business should already have done. That will include registering the asset with the Department of Home Affairs. It also will mean that there's notification obligations under that specific piece of legislation. So under the Privacy Act, currently, we've got 30 days to notify the OAIC, or as soon as practicable once a certain threshold's met. But under SOCI, depending on the severity of the incident, it may be that you need to notify the ACSC within 12 or 72 hours, respectively, depending on the incident. So really strict timing requirements. You know, coming to the question, in short, one, does it apply? And if so, what do you need to do? So you've got those two things. Plus there's further risk management programs that now need to be considered. So I think for businesses, first thing, find out if it applies, and then seek legal advice on that. And if so, understand what you need to do. It's not anything, you know, significant or novel. Businesses should already be doing a number of the things that are required. But yeah, if you get it, I'd recommend seeking advice on that issue to understand in a bit more detail.
Great, thanks, Aidan. And next question, I'll open up to the panel. It's in relation to class actions, particularly the one against Medibank. As you know, there's been a number of entities that have suffered significant breaches over the past year or so. In your opinion, do you expect class actions to regularly occur to any entity that has a significant cyber event or data breach, particularly in instances where there's significant media attention that surrounds it?
Perhaps I'll start with this one, but I'm interested in others. I think there'll continue to be class action activity, and part of it is, and you know, I'm a front-end lawyer, so I'm not a litigator, but I think there's a strategy behind class actions in that very few of them will run all the way through to trial or decision. Many are settled, very much with the involvement of the insurer, as well. So to Teresa's point about being careful about how much information threat actors know about your financial position, unfortunately, class action litigants will know quite a bit about the balance sheet sort of health of an organisation to fund a settlement. However, it will be more difficult. I think the fault test does raise the bar. That said, class action litigants will just claim, in my view, that the board was negligent. So they won't necessarily see that as a reason not to pursue a claim. One other factor which I think might be seen in the coming months is, if not statutory reform, ASX already has a very, very, very lengthy guidance note around continuous disclosure. So doesn't have the status of law, but it's sort of the Bible on how to comply. It's got very, very dense chapters on things like earnings guidance, etc. I wouldn't be surprised if there's some more specific guidance that's given to listed entities, disclosing entities around what they should be disclosing for cyber breaches. And that will, even beyond that, I think that will probably lead to more disclosures being made, even around the sort of messages that Eden was providing before. Hey, everybody, subject to a cyber breach, we don't know the extent of it yet, we're investigating, we'll let you know as soon as possible. And then quite regularly updating the market as they understand more. That's certainly a mitigant, and that will make it more difficult for a class action claim to proceed. So I think they'll still be there. I honestly think though they'll be more at the sort of the ASX 50, ASX 100 mark. Many financial services business fit within the broader sort of listed market or exchange. And I don't know that class action litigants will be as focused on them, but they certainly will for the Medibanks, the Optuses, and those primary ones. But Teresa, I don't know, do you have a different view? Do you, in your sort of business and thinking of that risk, do you see class actions becoming more prevalent?
No, I agree with what you're saying. The other interesting part is some of the other class actions that are out there where they're actually being brought by the customers. And I mean, what I think is going to be really interesting is how loss is actually quantified. I know overseas it's easier to bring class actions as a customer, but with regard to cyber. We don't have that legislation here at the moment. So I think that's going to be interesting to see how some of these, for example, the two of the Medibank actions actually do run, if they run, and how loss will be quantified in that instance.
Yeah, agree.
I was just going to say, I just echo all of those comments from both Teresa and James. Just add one last piece, which is part of that Privacy Act reform is looking to introduce, that breach of privacy and potentially a statutory tort for breach of privacy. So providing a new avenue for a class to bring a claim. So I suspect the answer to the question is yes, I do think we'll see an increase in class actions. That will be impacted by how damages are measured, by how successfully these things are run. But mostly I'm expecting, like James, that it will be targeted towards large companies who are seen as able to pay large sums of money in response to class actions. I'll finish up there, just mindful of the time.
Great. Well, yeah, in the interest of time, we might end the Q&A session there, but thank you for your questions, and I'll hand back to you, Eden.
Yeah, just in conclusion, just big thank you to everyone who's joined us today and registered for the event. We'll get in touch with you with a copy of it, and you'll have my contact details. So if you have any questions for myself or any of the panelists, please let us know, and don't hesitate to reach out. We have a full program of events scheduled for the next few days, including networking drinks. There's going to be a federal budget webinar and an M&A breakfast. If you'd like to register for any of these events, please click through the link that's being dropped in the chat now. Otherwise, thanks everyone for attending, and have a great day.
Thank you.
Thank you.